It is adjourned to the, have you informed the other side?
Yes, madam.
Least after 3 weeks.
Obliged.
Lordship, I would like to mention item number 24 on behalf of S staff in government, senior government advocate, Your Lordship. I'm for the appellant, for Your Lordship.
Hmm.
Your Lordship may kindly taken up this matter after 2 weeks.
Hmm.
I've taken the consent, Your Lordship.
Okay. On the request of the learned counsel MS,
Arbasar,
sir, the hearing is adjourned today, least after 2 weeks for hearing.
Lordship.
Your Lordship, I beg to mention item number 28. Kindly the matter may be taken up after 2 weeks.
2 weeks.
2 weeks.
28.
28.
Lordship, I am for a petitioner. We have interim hearing. Interim may be continued.
Okay. On the request of the learned counsel, Mr.
M. Kamsa.
Preparing for the respondent.
Respondent number 2.
Respondent number 2, the matter is adjourned today. Also heard, Mr.
T. Dodung for the petitioner.
Preparing for the petitioner. Least after 2 weeks. 2 weeks.
Yes, 2 weeks.
The interim of the pastor will continue until then.
Obliged.
Lordship, I beg to mention item number 29. I am on behalf of the petitioner.
Okay.
We have taken the consent from the other party. The matter may kindly be listed
On the
after
request of the
3.
learned counsel, Mr.
A. Gamre,
He come down. The matter is adjourned today. When do you want it?
after 3 weeks.
Least after
And
3 weeks.
also, Lordship, there's an interim order in this.
The interim of the pastor will continue until then.
Obliged.
Your Lordship, may I mention item number 13? I'll be filing wakalat number for respondent number 4, the substituted service, legal heirs.
Item number 13.
13.
When did you file the wakalat number? Today?
No, I will file today.
Review.
Yes.
Review. It should have been, who passed the earlier order?
My lord, I am for the petitioner.
Now, who filed the earlier order?
My lord,
Now, you are filing this review petition for.
Your honor had passed the.
my lord has passed now.
Oh, okay. Okay, when do you want? What do you want now?
This, I need to file wakalat number
Or you will be appearing for respondent number 4.
4.
So you need time.
Today I will file.
Okay, you file it, no problem.
My lord.
Wait for your turn then.
Okay.
My lord. My lord, I would like to mention item number 22. Kindly this matter may be listed after 2 weeks.
22.
2.
On the request of the learned counsel, Mr.
Petaso.
Kitaso. The matter is adjourned today, least after 2 weeks.
Yes. Hello, bless.
My lord, I beg to mention item number 14. The leading counsel is out of station. Kindly, a short date may be given, day after tomorrow, my lord.
Leading counsel is Simoti.
My lord, the mentioning is my lord made on behalf of the respondent.
You are present.
Respondent.
Oh, you are for the respondent.
Make it day after tomorrow, and my lord, it may be noted that no further adjournment shall be made in this case.
He has taken adjournment on earlier
My
occasions.
Since the last 2 years, my lord, other than adjournment, my lord, nothing is done in this case. So day after tomorrow.
Okay. On the request of the learned counsel, Mr. What is your name?
O Pangam.
No, Pangam. The matter is adjourned today. I have also heard Mr. C. Modi, the learned counsel for the petitioner. List this matter day after tomorrow.
Well,
What will be the date?
19.
19.
And no further adjournment shall be made.
And no further adjournment shall be given.
Also, my lord, yeah, item number 16. Matter may be fixed after 3 weeks' time.
You are for a petitioner.
Yes, my lord.
On the request of the learned counsel, Mr.
O Pangam.
Pangam. The matter is adjourned today. Least after 2 weeks.
Much obliged, my lord.
Item number 2.
May I please your lordship? Lordship, this is a contempt petition, lordship, against the alleged contemner.
Yeah, I will issue notice on the
Lordship,
heard Mr. J. Gini, appearing for the petitioners. Issue notice to the sole respondent. The petitioner said takes steps of service of notice upon the sole respondent by how he will send the notice by registered post,
Mr. Post.
by registered post with AD. List after 4 weeks.
Oblige.
Yes.
May I please, my lord, this is a bail application, my lord, under section 483 of BNHS, my lord. This accused, my lord, was arrested on 16 June 2024, my lord. So this accused has been in jail for more than 9 months now, my lord. His earlier bail application was rejected, my lord, and he was arrested on allegation of committing a crime under section 452 IPC and section 6 of POCSO Act, my lord. The
What is
allegation
what is the new ground? You have to take a new ground. Earlier one was rejected,
yes,
so you have to take a new ground.
my lord, on medical ground, my
Page 28, my lord. I'll just update the FIR, my lord. Before FIR, my lord.
28.
Yeah, no, before FIR, the complainant had already lodged complaint before the learned magistrate also, my lord. This is the in 2023, my lord. Your lordship will say order, but later on when the court said that no materials be there, so she withdrew this complaint, man.
Oh.
This is the withdrawal. This is man. After this, my lord, she filed the FIR. Lordship may kindly see page 18, my lord. My lord, the lordship got their page. The FIR lordship is subject. FIR against yes, such and such a power department, SEPA division for attempt to murder, criminal intimidation, grievous hurt, threatening, etc., and seizing his arms, pistol, revolver, along with the license there. My lord, same allegation which he was, which she leveled in the complaint case, man.
Okay.
She already the same complaint was lodged before the magistrate. This after this, my lord, in the subject, there's nothing like that, my lord, rape and all that. But in the body of that one, she said, your lordship, with due respect, submits that in 2018, my lord, I was invited to allege accused, namely such and such. This is the accused person, my lord. Power to travel to SEPA since the alleged accused was my relative. I to agree with him. His government vehicle before reaching SEPA, the alleged accused person started touching me inappropriately, to which I resisted. On resisting, alleged accused got violent, started molesting me by touching my thighs, breasts, and whole body parts. I was only 70 years of age and was not ready for physical intimation, man. This is the gist, man. When she alleges that 5 years back, when initial had relation, then she was underage. This is after the relation sold. Lordship, can you see the next page, my lord? The complainant, my lord. She such and such, wife of such and such. This accused person, my lord. Address is same as that, my lord.
The petitioner is Eka removed.
Yes. Now, my lord, after this, she also filed, my lord, divorce suit before the learned district court, my lord. That was already dismissed by the learned district court, Bomdila, my lord. But, my lord, she also filed a complaint, my lord. That's the gist, my lord. Can you see page 20, my lord? This is the complaint she lodged before the special judge, POCSO, my lord, Bomdila. Alleging that the OCPS is not registering her case, man. Now, my lord, what I'm submitting against this, my lord, when the learned magistrate of the special court issued, my lord, that direct lordship just Kindly see, my lord, we are afraid of this page 25, my lord, the order of learned court, my lord.
Is it a proximity?
Yes, Your
Yes. So we have made the alleged victim as a party also, my lord, respondent number 2.
The notice will have to go.
Yes, Your Lordship.
Yes, no,
Yes,
Heard
Your
Mr. P. Tapo, appearing for the petitioner, heard Mr. T. Ete, till the petitioner public prosecutor for the state of Arunachal Pradesh. Issue notice, no formal notice is required to be sent to respondent number 1, as because Mr. Ete has accepted notice. Extra copy of the petition shall be provided to him. How you will send the notice?
my lord, through
Office of PP, Your Lordship,
office of PP, man.
and through one registered post as well.
Huh?
Through Office of PP and registered post as well, Your Lordship.
As well as through registered.
Yes, Your Lordship.
The petitioner shall take steps for service of notice upon the respondent number 2 through the office of the public prosecutor as well as by registered post to ED.
Yes.
When it will come?
My lord, it's 2023 matter, may I pray, my lord, interim at least, my lord. Otherwise, my lord, Miss Seema.
Let it be listed after a week, Your Lordship. Let it be on, Your Lordship,
2000
24th, Your Lordship, Monday itself.
Monday, 24th.
My interim at least, my
Monday.
lord, because of government servant, my lord, a assistant engineer, my lord.
Prayer for interim order shall be considered on that day,
Yes, Your Lordship.
on 24th.
Oblige, Your Lordship.
Obliged.
Item number 5.
Yes.
My lordship.
FIR was lodged on 15/2/2024. Then AB was moved to this AB number 115/2024 and interim was granted. And the interim was granted on 18/12/2024. Then the interim was rejected on 7/1/2025. Then thereafter,
This Supreme Court order.
Yes, Your
yeah,
Lordship.
yes, AB was filed but withdrawn.
Withdrawn.
After, yes, AB, this is AB number 6/2025 was filed but withdrawn. Then thereafter, SLP in the form of SLP was filed, but it was dismissed on 21/2/2025. Then
But it
again,
is-
another AB was filed.
But it is mentioned here,
Huh?
it is in paragraph 2, it is mentioned here, if the petitioner surrenders and applies for regular bail, such application shall be considered.
Yeah. Peripheral arterial disease. He has been advised for the procedure of regenerative cell therapy, system cell therapy. The date of procedure is fixed for 24/3/2025. And he has been admitted already in the Medina Hospital on 6/3/2025.
No, for that matter, you have to go to the Supreme Court again.
And
Because once Supreme Court has rejected the bail application, if you have a new ground, then you have to approach the Supreme Court again.
Separate ground, separate.
Now, grounds is separate because at that time,
Maybe ground may be good, but High Court cannot interfere.
why?
Once rejected by the Supreme Court, if you have a new ground, then you have to approach the Supreme Court again.
The new ground is that I have been admitted to the hospital and date of operation that has already been fixed. And while they had, the SLP was moved, that time I was not admitted to the hospital
Yes, I understand.
and operation date was not fixed. This is the changing of fate and circumstances. Now, at this, we have informed to the people that we are not absconding. We are in under treatment. That is Annexure 12, page 113. Intimation of medical treatment of my husband, Sri Tabing Lamgu. With reference to the above stated subject, I would like to inform you, good office, that my husband had been falsely implicated as an Alex accused in the Sayang Tajo PS case number 6 of 2024, registered under section 103, section 2, oblique 238A, oblique 61-2, BNS 2023. My husband is a peripheral arterial disease patient that in the year 2022, he was admitted at Medina Hospital, Gurgaon, and had undergone major surgery where his right leg big toe has to be imputed. Medical document enclosed. Recently, on 11/12/2024, my husband consulted with doctors in Trim Hospital, Naharlogon, and after medical examination, he has been referred to Medanta Hospital for further treatment and closed document. Now, he is undergoing medical treatment at Medanta Hospital, Gurgaon, Haryana, medical document enclosed. Therefore, non-appearance of my husband before your good office is not deliberate but due to health problem issues. As such, your good office may be pleased to consider the same and further may be pleased to have a sympathetic approach while dealing with my husband, Sri Tabing Lambu. Now, consider this. I would like to submit some rulings. First, this is 2017, volume 13, SCC 555, Rani Dudeja versus Haryana, Para 3. We are afraid the stand taken by the High Court cannot be appreciated. The petition was for anticipatory bail and the ones which had been filed earlier might have been withdrawn in a given situation without inviting to consider the same on merit, on sense of circumstances. Another application under section 430 CRPC was filed. The High Court should have considered the same on merit. The principle of res judicata could not have operated in an application for bail. Now, another ruling is 1978. SCC 579, Para 2. This is between Babu Singh and others versus State of UP. Para 2. Bravely, we will state the fact pertaining to the present petition and prayer and proceed thereafter to resonate on the relevant criteria in considering the interlocutory relief of bail. Right at the we must mention that At an earlier stage, real applications for bail was rejected by this court on September 7, 1977. But an order refusing an application for bail does not necessarily preclude another. On a later occasion, giving more material, further development, and different consideration. While we surely must set store by these circumstances, we cannot accept to the faintly that we are barred from second consideration at a later stage. An interim direction is not a conclusive adjudication, and updated reconsideration is not overturning an earlier negation. In this view, we entertain the application and evaluate the merit, pro and cons. Now, another is this is on Guwahati High Court ruling. Runu Roy versus State of Assam, para 14. Para 14. Accordingly, we hold that within the parameters set forth by the apex court in Babu Singh Supra, which would also apply to the applications filed under section 438 and 439 of the code, a second application under section 438 CRPC would be maintainable and constrained to overrule the view taken by the learned single judge in Utpal Sharma Supra. The division bench decision. Now, huh? 2004, Volume 7, SCC 528, Kalyan Chandra Sarkar versus Rajesh Ranjan Elias Papu Yadav and others. In para 12, in regard to cases where earlier bail applications have been rejected, there is a further onus on the court to consider the subsequent application for grant of bail by noticing the ground on which earlier bail applications have been rejected. And after such consideration, if the court is of the opinion that bail has to be granted, then the said court will have a specific reason why is, in spite of such earlier rejection, the subsequent applications for bail should be granted. Now, there is another Supreme Court ruling, this 224 SCC online, Punjab and Haryana, 14696, para 62, 10.5. 10.2. The Honorable Supreme Court, in case of Babu Singh case, Supra, has held that rejection of a bail petition does not by itself forbid a court from considering another one later in point of time. It can be safely interfered that the decision of a court qua bail petition, whether regular bail petition or anticipatory bail petition, is essentially an interlocutory order, and hence the concept of res judicata does not apply. almost all the Honorable High Court have enunciated the view applied. Almost all applied that second successive plea for grant of anticipatory bail albeit with the some circumstances and material sense of the circumstances being a prime requirement. The full bench of Honorable Rajasthan High Court, in case of Ganesh Raj case, Chopra, the full bench of the Honorable Kolkata High Court, in case of Sudeep Sen case, Chopra, the division bench of Honorable Andhra Pradesh High Court, in case of K. Gajendra case, Chopra, the division bench of the Honorable Madhya Pradesh High Court, in case of Imrantial Vishwakarma case, Chopra, and the division bench of the Honorable Guwahati High Court, in case of Runu Roy case, Chopra, have inexorably assured this exposition. 10.5. No rigid or universal criteria can possibly be delineated to conclusively govern the exercise of judicial discretion. In determining as to what would constitute, as the above stated, substantial change in the circumstances, textual flexibility, one addition or different fact may make a sea of differences between two cases. There is no gainsaying that each case has its own distinct and unique fact, and hence exercise of such a judicial power is best left to the judicial discretion of a court in accordance with the settled norms of our jurisprudence.
Medical ground.
And now we have this fourth anticipatory bail, which we move on. It is completely changed. The facts and circumstances of the case are completely different, though our earlier petition was rejected. This is 2008, Volume 7, HUC 591, Para 8. Suresh Chandra Ramanlal versus State of Gujarat in NLS. Only fact circumstances of the case, and more particularly having regard to the health of the applicant, this court is of the opinion that interest of justice would be served if the applicant is enlarged on anticipatory bail subject to certain conditions.
BNS, even BNSS.
This is Rajasthan High Court. Rajasthan High Court. Nahar Singh versus State of Rajasthan. This is a fourth application for anticipatory bail filed by Nahar Singh in this court. His previous applications were dismissed by 3 different judges of this court after going through the 7 papers and the fourth application. The petitioner has pressed for grant of anticipatory bail on ground. He has produced the medical certificate showing that he is suffering from hypertension and chest pain and is admitted in medical ward, General Hospital, Bharatpur since 30/10/2082. learned public prosecutor had contested the application for anticipatory bail mainly on the ground that 3 previous applications for anticipatory bail have been rejected by this court and the petitioner did not surrender himself in the court of learned magistrate. Having considered all the facts and circumstances of the case and looking to fact that the petitioner is suffering from hypertension and chest pain and is admitted in the General Hospital, Bharatpur, since 30/10/2082, and that all other co-accused have been released on bail. I consider it proper to grant anticipatory bail to Nahar Singh petitioner under section 30 CRTC and direct that he shall be released on bail, provided he furnish personal bond in the amount of 6,000. Yeah. This is a High Court judgment, Delhi High Court, para 2 and 3, para 2. The status report indicates that the petitioner's left side is paralyzed, left hand and left leg. It has been submitted that other accused persons are already on bail. In view of the medical condition of the petitioner, the petitioner is admitted to bail on his furnished personal bond in a sum of 10,000 with one security. Now, here in my case, that we are not challenging here in the case. We are not challenging the Supreme Court order. We are coming to this court up only on the changing of facts and circumstances of the case. Therefore, if we will not follow the procedure as by the doctors, we are approaching this honorable court or press ground of need of regenerative cell therapy, without which the applicant would lose his leg or hand. Now, the characteristic of the peripheral artery disease is some of his vein arteries fail to supply the blood to his leg, to his hand, and just to regenerate it, he needs the operation. And this sort of disease, he has not been treated not only after the case registration, but whereas he was already operated and his knee has been, one of the leg finger has been already amputated in 2022. So he was in constant touch with the medical since then. Now, in the case of Sri Khan Upadhyay, where the accused, after rejecting of the anticipatory bail, he was absconded. The court has issued Section 82-83 of the CRTC. The court has declared that he is a proclaiming absconded. But in my case, he is not absconded, and we have given intimation to the police. Hello. So, and apart from that, I was granted interim bail for, already granted for around 17 days. And during the 17 days interim protection, Entirety of my statement has already been recorded by the police. And there is no question of absconding because he is a practicing lawyer. The petitioner is a practicing lawyer of this court. So his duty itself is in the court. So when he will attend the court, it is admittedly, there is no chance and possibility that he will jump over if any interim would be granted or any liberty would be granted to the present petitioner. Therefore, this is a pit case to grant the interim till to the date of the operation. Otherwise, this is his fundamental right. Taking treatment for better own health is already granted for own fundamental right.
May, please, your lordship.
Therefore, my lord, case record may be called forth and during the pendency, interim protection may be granted as an interim.
May it please your lordship. Lordship, the submission made that he has not been proclaimed. I have given the proclamation order, your lordship, along with the bunch of the order of the Supreme Court, your lordship.
Your Lordships, I'm begging to appear for the complainant only as an officer of the court. I was present in the Supreme Court. The Supreme Court records my presence. My lords, in the Supreme Court, after a considerable amount of arguments, a concession was given by the court only on the promise that he will surrender. The learned senior has been misinformed. Secondly, my lords, the judgment in Pradeep Sharma is categoric. Once a proclamation order comes into effect, an anticipatory bail is just not maintainable till the proclamation is set aside. My lords, my learned colleague is giving the Pradeep Sharma judgment. Section 16 is clear. Paragraph 16 of the Pradeep Sharma judgment, my lords. Once a proclamation is in effect, an anticipatory bail as per the Supreme Court is not maintainable. He was declared a proclaimed offender on 12th February 2025, my lords. There is another judgment, my lords, of Honorable Justice J.K. Maheshwari. It was proclaimed only on the 22nd of January this year, where the Supreme Court has come down very heavily on individuals filing multiple anticipatory bails once it's been dismissed. This is Pratik Arora, my lord. It's an order of the Honorable Supreme Court, para 9. The court, in fact, imposed costs on the individual, saying you are circumventing the law and playing with the procedure. Now, if the ground is that there was an individual who had a pre-existing condition, the learned senior said in 2022 his fingers had suffered. He should have raised this point before the Honorable Court or before the Supreme Court. You cannot keep manufacturing new grounds, especially which are pre-existing, and circumvent the law.
Yes.
Yes, your lordship. Your lordship, I have also seen the proclaimed proclamation order, your lordship. Also, your lordship, if your lordship will come to page number 48, your lordship.
Where is the proclamation order?
Proclamation order is along with the bunch of where the Supreme Court order was given. Yes, your lordship.
It is not clear.
Yes. The first is the non-bailable order and then the proclamation order.
All right.
Yes, your lordship. 4 of the accused were on order of proclamation again, 4 accused were given, your lordship, out of which 3 of them has surrendered, your lordship. Also, your lordship, the ground that has been put forward, your lordship, medical ground, that was already considered on the first date of the bail rejection. Your lordship will see dates 7/1/2025, your lordship. The same ground was put forward on the second occasion when the bail was moved, which is at page number 48, your lordship.
Yes.
the second bail was rejected, your lordship. If your lordship will kindly come to page number 81, your lordship. 81 again. And not 81, your lord, 51, your lordship. Paragraph 13 is 13 and 14 are the relevant paragraph where even the same ground of medical was taken into consideration, and the court taking that plea has rejected, stating that the same ground was also the first rejection bail order, your lordship.
The same ground already taken in this court.
Yes, yes. More particularly para 14, your lordship.
Okay, all right.
Yes.
Heard the learned senior counsel, Mr. M. Katin, assisted by Mr. Preparing for the petitioner. RMS JGNE, the learned traditional public prosecutor for the state of Assam. You are TGNE or JGNE?
TGNE, your lordship.
TGNE. Heard Mr. What is his
Abhimanyu
name?
Tiwari, ma'am. Abhimanyu Tiwari.
Mr. Abhimanyu Tiwari, the learned counsel appearing for the informant. Where? This is an application filed under section 482
Oh, 482.
of the BRSS 2023 in respect of Sayangtajo PS case number 06 of 2023. Where? The present petitioner has been accused of committing offenses like murder, causing disappearance of evidence, and of criminal conspiracy. His bail applications were earlier rejected in the court. Therefore, he approached the Honorable Supreme Court. Filed special leave petition within bracket criminal number 2761 up to 2761 dash 2762 stroke 2025. The Honorable Supreme Court dismissed the SLP on the ground that there was no ground for granting pre-arrest bail. Thereafter, the present bail application has been filed on the ground that the petitioner is undergoing treatment at New Delhi.
Medina Hospital, Haryana.
For treatment of non-reconstructible peripheral artery disease. Fair. MS Zini has pointed out that proclamation order has already been issued against the present petitioner. Your Upamanyu, what is his name?
Abhimanyu Tiwari.
Tiwari. Mr. Tiwari has also pointed out that unless the proclamation order is cancelled, the bail application cannot be considered. Fair. I have considered the submissions made by the learned counsels of both sides. The petitioner has been named as an accused in the FIR. Since the Honorable Supreme Court has rejected the bail application of the petitioner, even then, since the Honorable Supreme Court has rejected the bail application of the petitioner, this court is not supposed to consider the bail application as a matter of judicial propriety. Therefore, the present bail application is found to be devoid of merit and stands dismissed accordingly.
My first lordship,
Yes.
there is a gross irregularities in the application lordship. Page number 13 is missing. Page number 13 is missing.
Page number 13.
Page number 13 is missing, and there are two set of page number 8. Page number 5 come before page number 4.
Number 6 will go.
My lord, item number 6.
Yes.
Lordship is taking item number.
May I, my lord? But here, my lord, with all respect, my lord, to the best of my knowledge as a student of law, my lord, the case has been registered business dispute between two persons, my lord. Here in the section of law that has been attributed is 316, my lord, with all respect, my lord, 5. That cannot come in at any moment, my lord. So criminal, my lord, by amongst government sub and bankers like that, my lord. And my lord, this case has been lost so that, my lord, certain checks which are in my hand to get back my dues, my lord. A civil dispute, my lord, civil sum dispute, my lord, has been given the color of a criminal case, my lord. That cannot happen, my lord. If your lordship permits me, my lord, I can read the FIR, my lord.
Okay, please read the FIR.
Yes, my lord. With all respect, my lord, that occurs at page 20, my lord.
Yes.
Page 20, my lord.
Yes.
May I just read it, my lord? The top portion, my lord, I'm missing out, my lord. With most respect, it is to state the few lines for your kind consideration and necessary action. These are my names and everything. Thereafter, leaving aside 1, 2, 3, 4, 5, 6, 6th line, my lord. From 7th line, I begin, my lord, the material part. However, due to delay in payment of bill, the first informant's bill, my lord, he is to get bill from the Ministry of Road Transport and Highway Department, Government of India. There was slight delay in making payment to the accused, the petitioner before your lordships, of some remaining amount to the said company, meaning thereby money is due to the accused, it is admitted, my lord. Moreover, I was kept a bank guarantee. He gave a bank guarantee, my lord, the first informant, height number so and so, dated so and so, amounting to rupees 2 crores, only in favor of the aforementioned company, to discharge my liability, the first informant's liability, in default of making payment, any amount in consideration of supplies taken from them, meaning thereby, with all respect, my lord, supplies were given by the accused. He has been made an accused unnecessarily, my lord. And money is due to the accused, my lord, admitted. Have I made my position clear, my lord?
Yes.
Thereafter, my lord, at the same time, I had issued a blank so that, my lord, I do not lodge a, my lord, Negotiable Instruments Act case because further amounts are due. At the same time, I had issued a blank check, I check number so and so as a security to present to the concerned bank if the aforementioned BG is not encased. However, the said BG was already been encased. Encasing the BG is to fulfill the liabilities, and thereafter for further liabilities, I can go for, my lord, the NI case. There is no bar. Encased without any intimation to me. Despite forcefully encasing the aforementioned BG, no force, BG amounting to rupees 2 crores on 10/1/25 from the SBI Naharlagun branch on 24/2/25, both the alleged persons presented the said blank check before the bank to bounce it with an intention to file a case under appropriate section of NIA Act against me. The only intention is to prevent so that I cannot file NIA case, and I'll place certain correspondence between the parties, my lord. Further, it is to mention here in that insufficient fund in the account against which the blank check was issued. Now, my lord, the correspondence I'm placing before your lordships. Lordship, may kindly have a look at page 76. And my lord, the section of law attributed cannot come in. First of all, my lord, and thereafter this later, my lord.
So sent an email. That is
This is sent through email. In page 77, the email identity I have given, my lord. It is to me, the accused, by the first informant, my lord. Subject, request, that is page 76, my lord. Lordship may have found it, my lord.
Yes, yes. Yes.
Request to hold of encashment of BG for period of 15 days, starting 10/1/25. I see so and so is the first informant, my lord. It goes on and on, my lord, to the tune of 2 crores on our behalf for a period of 15 days, starting so and so. I am accepting that I have a total outstanding of rupees 2 crore 21 lakhs admitted, my lord. Bank guarantee is 2 crores. So I can file NIA case for the less to 21, my lord. Rupees 2 crores so and so, on so and so, which will be cleared by my personal resources within 15 days, starting 10/1/25. And if I fail to do so, I have no objection in encashing the encashment of BG issued on our behalf by SBI, post the request grace period. My lord, bank guarantee is with me. It was given because if dues are not fulfilled, my lord, I can encash the bank guarantee. I have encashed it. That is not an offense, my lord. My lord, bank guarantee is for 2 crore. Regarding race 21, my lord, there were 3 checks. My lord, if I lodge a, my lord, NIA case, can he lodge a criminal case against me to thwart it, my lord? That cannot happen. With all respect, my lord. This is a case, my lord, possibly where there is no case, will come for quashing at a later point of time, my lord. And my lord, may I place an authority of the apex court exactly on the same line? My lord, that authority I have placed before your lordships, my lord. Joy Sri and another as, I'm sorry, my lord.
Yes.
My lord, with all respect, my lord, that has been reported as recent as on 2024, SCC online, SC 54. Here I read para 4, leaving aside 3 lines from the top, my lord. This court has time and again cautioned about converting purely civil disputes into criminal cases. Any effort to settle civil dispute and claims which do not involve any criminal offense. My lord, 316(5) is not in my lord, operative. By applying pressure to criminal prosecution should be deprecated and discouraged, my lord. And subsequently, pre-arrest bail has been granted in the case where the authority is also together.
Okay, I will give you interim.
My lord, my lord, my lord.
Heard Mr. B.K. Mahadan, the learned counsel appearing for the petitioners. Heard Mr. I forgot your name. The learned additional public prosecutor for the state of Assam. Call for a case day. Fair. Heard the learned counsels of both sides in the matter of a prayer for interim protection. I have gone to the FIR. Now this court is of the opinion that both the petitioners deserve to be given interim protection at this stage. Therefore, as an interim measure, it is hereby directed that in the event of arrest in connection with Naharlagun PS case number 27 of 25, the petitioners Otul Sharma and Ankit Mishra,
They are not to be harassed, my lord.
alias Ankit Mishra, shall be released on bail of rupees 20,000 each, which surety the like amount to the satisfaction of the arresting authority. Both the petitioners shall cooperate with the police investigating officer as and when called. List again on give a date for case day.
Next week.
After 2 weeks. List after 2 weeks.
Can it be next week?
Date, my lord.
After 2 weeks.
My lord, my lord. My lord.
Number 7. Yes.
My lord, if I may. My lord, this
Petition.
Yes. But this petition is for quashing of criminal branch police station case number 13 of 2021. It is registered under section 153, 153A, 500, 505, 506, and 34. My lord will find the FIR as page number 12. My lord, basically the gist of the case is that an FIR was lodged by a student organization saying that some defamatory words have been used by some residents of Assam. A viral video was being circulated whereby
It will go for admission hearing on the next date. Heard Mr. G. Tallo. APA for the petitioner, heard Mr. J. Sering, the Lord Public Prosecutor for the state of Arunachal Pradesh.
SPP for SIT,
And,
special DP for
the Learned Special Public Prosecutor for
SIT.
SIT. List this matter up to 2 weeks for admission hearing.
my lord, there is an interim prayer, my lord. Because we have already appearing before the Lakhimpur CGM, my lord.
The prayer for interim order shall be considered on the next date.
My lord, the investigation is going on, my lord. Can it be next week at least, my lord, hearing maybe? If interim is not given, my lord.
After 2 weeks.
Much obliged.
Eight. Here, no, so,
Up to issue notice only because they're private respondents in this case. Matter pertains to 376, my lord. Matter pertains to 376. So they are private respondents in this case.
Okay.
The notice has to go at this stage.
You have not made the private respondent a party.
Lordship, they have impleted.
My lordship, we have impleted, lordship. We have made them as a party, lordship. Informant and informant victim, lordship.
You have made informant a party here.
Yes, they are. Which you can.
Wait, it is not mentioned here in your title page.
We are for item number one, lordship.
Oh, 7 and 8 are, my lord, connected matters.
Oh, so.
7 and 8.
Oh, then when you write the order in 7, list after 2 weeks along with item number 8.
7 and 8 are connected.
Along with item number 8.
My lord, apologies, my lord, till the next date, can there be some protection from investigation? Is because we are already facing trial in Lakhimpur, my lord.
On the next date, it will be considered.
Much
This is also Mr. Talo's case. Item number 9.
No.
Oh, this is 8.
Lordship, I'm representing.
Item number 8.
Lordship, I am in the interim, lordship, I am seeking a stay of the criminal proceedings that has been, that is.
Criminal proceeding going on.
Lordship. And next date is fixed on 21 of this month for examination of PWs.
Mr. Sering, will you appear for respondent number 3?
Yes, my lord. 1 and 3, my lord.
1 and 3.
2 is a private respondent. She's the informant.
Notice has to go.
Yes, my lord. Since this matter pertains to 376. Therefore, my lord, a notice has to go, and then on the next occasion, my lord, the interim prayer can be considered.
Heard Mr. J. Gini, appearing for the. Heard Mr. J. Sering. Your public prosecutor as
SIT, my lord. SPP.
Special public prosecutor for SIT. Appearing for the respondents 1 and 3. Issue notice. No formal notice is required to be sent to the respondents 1 and 3. As because Mr. Sering has accepted notice, extra copy of the petition shall be provided to him. The petitioner shall take steps for service of notice under respondent number 2 through the office of the public prosecutor, as well as by registered postal AD. List of the 4 weeks. After appearance of the respondent number 2, the prayer for interim order shall be considered. List after 3 weeks.
Lordship, on 21st, the trial examination of 1, 2, and 3, including the victim, and then the informant will be examined, lordship. Now that I have a prima facie case, lordship, where this honorable court can interfere into the criminal proceedings that has been carried against me before the London trial court below. Lordship, these allegations, all allegations is lodged out of nullified, lordship.
Who is the FIR?
FIR, lordship will find it page 28, lordship. Lordship, gist of the case is that the alleged victim is alleging that she has been subjected to sexual intercourse in the private residence of the alleged accused in the bathroom.
Or in her own house.
Government of Arunachal Pradesh, madam, which is at page 26.
26.
Yes, page 20. I'm sorry, madam, 25. Page 25, madam. Is issued on 24th September 2019. May I read the content of it, madam? Consequent upon amendment of General Financial Rule, Rule 161, 1 and 2, 182, 2012 of 2007, in respect of tendered advertisement for the purpose of procurement of goods and services. The need for publishing advertisement in newspaper for procurement of goods and services has been done away with. This has now been replaced by mandatory e-publishing of advertisement on Central Procurement Portal CPP at such and such. Government e-marketplace GEM and website of the departments. Therefore, madam, direction is issued, madam. Therefore, all the departments of the offices of the government of Pradesh are directed to strictly adhere to the provisions contained in GFR 2017 regarding publication of advertisement for procurement of works, goods, and services, and to publish the tender through government e-procurement system of NIC/GEN through URL links only. There are 3 links has been given, my lord. My lord, this tender, my lord, has to be, my lord, issued through these 3 links. The contention of the petitioner is that, my lord, offline tender has been, my lord, done away with. Therefore, my lord, online tender has to be, my lord, invited, my lord. In spite of that, my lord, this notification, my lord, the respondent has, my lord, issued this offline tender, my lord. Therefore, my lord, the petitioner is approached, my lord. The approach to respondent number 3, my lord, who is the executive engineer who have issued this NIT, my lord, which is at page 20, my lord.
Okay, what is your reply?
Yes, my lord. My lord, will hear. He is, my lord, not disclosing all the fact, my lord. Before, my lord will look into this, my lord. My lord will kindly have a look at this page number
Just a minute.
30, my lord. Before that, my lord will kind of 30, my lord. Same grievances, my lord. He is raised before the concerned authority, my lord. Now, concerned authority, my lord, has in page number 30, reply him, my lord. The notification, my lord, rely by him, my lord. He is already in suppressed, my lord. Now he is not disclosing all the fact, my lord. My lord, kindly now in terms of this notification, my lord, the notification rely by my lord, him, my lord, has already been, my lord, suppressed, my lord. Now that was already my lord had come page of 30, my lord. So page of 30, my lord.
In superstition of earlier government.
My lord, this was replied to him, my lord. Now he is not disclosing this fact to the this honorable court, my lord. I find, my lord, such a litigation, my lord, these have no relief, my lord. Ultimately, he need to bring all the fake, my lord, before this honorable court, my lord. Page 29, my lord. Last para, I read one para 29, my lord, to him, my lord. This is by the concerned authority, my lord, to him. With the above representation letter, you had also attached a notification of principal secretary such and such dated 24 September 2019, my lord, rely by him, my lord. In a publication of advertisement for procurement of goods and service and published the tender through government system of NIC. While honoring the above notification, it is to inform you, please refer the notification issued by the Chief Secretary 2020. I have placed, my lord, which is suppression of earlier notification, my lord. Now my lord, he is not disclosing this fact, my lord. Already his grievances, my lord, has been taken care of, my lord. It is this, my lord, yes, my lord, this work order has been issued in this case, my lord. My lord, and he will be a necessary party, my lord. Yes, my lord, will let them withdraw this, my lord. If he any grievance, my lord, he will make a party to this new party, my lord. In the absence, my lord will not pass any.
Work order already given.
Issue, my lord. LOI already issue, my lord.
My lord, I have filed one RTI before the, my lord, executive engineer. my lord.
This is not fair, my lord.
My lord, I have made specific amendment in my petition, my lord. I have filed RTI application. That RTI application has not been punished to me till date. So, my lord, I have no knowledge, my lord. What is the outcome of the, my lord, that
You
is.
may make him a party.
But he was having knowledge of this order, my lord, suppressing earlier order, my lord. But then he's today also he's relying on the notification. my lord.
Regarding this notification, my lord, my lord, I will.
That is not fair, my lord. That should be not.
My lord, regarding that, my lord, so already work order has been issued to some, my lord.
I'll give a copy to him, my lord. Let him withdraw, my lord. Let
Both
come again, my lord.
but minutes and my lord, that work order may be punished to me. I will, my lord.
You
Come
are
appraise, my lord.
You are Mr. H. Lampu.
Yes, my lord.
Heard Mr. H. Lampu appearing for the petitioner. Heard Mr. L. Parme. Parme is for all the respondents.
1, 2, 3, and 3. Yes, my lord. All the respondents.
Appearing for all the respondents. Where this application under Article 226 of the Constitution of India originates from an NIT
Dated 27 February 2025.
dated 27
February 2025. Page 26.
2025.
25 marks.
25. Mr. Lampu submits that pursuant to the notification dated 24 September 2019, all NITs of the government of Arunachal Pradesh must be electronically advertised. But this tender was not published that way. Rather, it was published in a hard form. In reply, Mr. Parme has produced another notification of the state of Arunachal Pradesh, which is dated 19th August 2020. According to this notification, NITs can be published in hard copy. Mr. Parme further submits that the work order has already been given to Messrs. PP Sangbia Enterprise, and therefore Messrs. PP Sangbia Enterprise must be made a party in this writ petition. I have considered the submissions made by the learned counsels of both sides. This court has reason to agree with Mr. Parme. Therefore, the petitioner is directed to implead Messrs. PP Sangbia Enterprise as respondent number 4. After appearance of the Messrs. PP Sangbia Enterprise, this representation shall be considered for admission hearing. List after 3 weeks.
Highlights. My please, Lordship, my lord, here I'm challenging frequent transfer order passed by the respondent authorities in regard of the petitioner. The petitioner has been constantly been transferred. She is woman aged about 54 years. Now she has not even, Lordship, the guidelines, Lordship was in Arunachal Pradesh, minimum tenure is 2 years. She has hardly completed 1 year and the impugned transfer order has been passed. And why the transfer order has been passed? The worker of the concerned minister, who is also local MLA of that area, he was extra things my lord, regarding concerning tea state, my lord. When the petitioner informed him about the procedural that has to be adopted by government in sanctioning, my lord, it was regarding tea garden. He got furious and my lord, he openly fired his pistol in front of the petitioner in the spot itself. Thereafter, he threatened that he will transfer her within a week, my lord. As per the my lord, the statement, my lord, the impugn transfer order has been passed in a very short period. My lord, we are not against that, my lord, it's exigency of service, we know it, my lord. The petitioner will be transferred, my lord, in accordance with whenever government wants, my lord. But the petitioner should not be transferred in this manner, my lord. Just to accommodate someone and on the behest of some who has no business in the department. So
now where she is posted?
She is posted at Longding, my lord.
Longding.
Yes. And my lord, because of frequent transfer, her daughter has already lost 1 year of her academic career, my lord. She ought to have been in class 8, my lord. Because she was constantly transferred, she lost 1 year. She is in class 7 now. Therefore, at least, my lord, that is the lordship will kindly see the government's own guideline, my lord. The minimum tenure is there, my lord. And this March, they shouldn't be transferred in this month, especially when their education school have examination and all that, my lord. This is their own guidelines they are violating. I admit, my lord.
Mr. Parme, what is your reply?
My lord will see, my lord, this order, the transfer order is of 5 February 2025, my lord. Already 1 month past, my lord.
No, but we have categorically, I received a transfer order on 24, my lord. And I file a representation on 25th, category statement in my writ petition.
My lord, this, it is all 1 more month old, my lord. This, the private respondent, my lord, has already been released on 5 March, my lord. And subsequently, so that is joining. This is the release order, my lord. This has been released, my lord. And private respondent, my lord, has already joined his plan. Now, about his submission, my lord, about some minister. Now, my lord, no, my lord. Here is the submission made by senior counsel, my lord. There is no such plea, my lord. If he is making made up his case on those allegation, my lord, those party need to be those person need to be party in this case, my lord. But my lord will see, my lord, neither minister, my lord, in a no yoker is party, my lord. On such uncertain allegation, my lord will not intervene. This is totally in public interest, my lord. Looking into his performance, my lord, is a order, my lord. Now, at this system, my lord, at the private respondent, my lord, has in terms of complaints of that
private respondent already joined.
Already joined.
My lord, that's why if your lordship allows.
Therefore, my lord, at this, my lord, let.
No, my lord, kindly, my lord, see the impugn order, page 22, my lord. I have not yet completed, my lord. The impugn order, page 22, my lord. So posting such and such, my lord.
Yes.
Yes, my lord. So, my lord, may kindly see. This is the order, my lord. I received this only on 24, my lord. Immediately, madam, my representation is pending with the responding authorities, madam. I filed on 25th. It's
representation also, my lord, will see, my lord. He is not the competent authority, my lord. His transfer order is issued by the secretary, my lord. Now he has submit representation director, my lord. He is not a competent authority to my reverse transfer order, my lord. At the most, my lord, yes, his representation, my lord, he can submit a representation to appropriate authority, my lord, and appropriately look into it, my lord. That is the only law. Otherwise, in public exigency, my lord, this is DO is a responsible officer, my lord. All areas, farmer of the area, my lord. Now, it is any enterprise, my lord, we surely the whole public, my lord.
Madam,
so when the
records may be called for, madam. If there is any public interest, madam, I don't have any case, madam. But if the notification, the transfer is initiated, madam, for extraneous consideration, definitely this honorable court will interfere in the matter.
No, sir, please, they are in record, my lord. He is,
No,
that private plea, my lord. That cannot be, my lord.
No,
For
therefore,
that, my lord, he need to plead it in his case, my lord, so they would reply, my lord.
therefore, I have called,
Yeah, whole plea, there is no such plea, my lord. Neither minister is a party, neither worker is a party, my lord. In absence of that plea, my lord, that, my lord, will not into those aspects, my
no,
lord.
but
If we want to sustain those allegations, my lord, let him amend his petition, my lord.
no,
I'll produce a
not
record, my
required.
lord. That is amend his read petition, my lord, saying this, this is an allegation against the minister concerned, and on initiation of those, my lord, we have to issue the transfer order, my lord. We will reply appropriately, my lord. In absence of those plea, my lord, how we can make reply and how this court will consider those aspects, my lord. My humble submission, my lord, if you want to file representative, let he file a representative before the appropriate director is not a competent authority to reverse his transfer order. It is the secretary or the commissioner, in our case, commissioner, my lord. Commissioner will consider his case, my lord. But the situation here is, my lord, the person might already join third person matter. And this is 1 year, 1 month old, my lord.
No, normally in these matters, court do not interfere.
My lord,
Normally in these matters.
No, my lord, that is a settle, my lord. No,
that's why
Courts do not interfere.
I admit to it, my lord, the
But
court,
I will do one thing. I will issue notice to the private respondent.
No, no, no. And on his API, interim.
Or Mr. Peter, appearing for the petitioner. Or Mr. L. Parmedil and government advocate. Your government advocate.
My lord, pardon me, my lord. 1 and 2, my lord.
Huh?
1 and 2, my lord.
For the respondents 1 and 2. Issue notice. No formal notice is required to be sent to the respondents 1 and 2. As because Mr. Parme has accepted notice, the petitioner shall take steps for service of notice upon the respondent number 3.
yes.
By registered post-it AD. List after 3 weeks.
Extra copy, my lord, I will require.
Definitely.
Extra copy of the petition shall be provided to
Hello.
Mr. Parme.
High level.
Yes.
My lord, the writ petition, this writ petition, my lord, challenge the, my lord, that technical bid evaluation report dated 6/1/2025, whereby, my lord, the technical bid of the writ petitioner was rejected. My lord. Thereafter, my lord, this financial bid was open. That is under challenge, my lord. And my lord, pursuant to the order of this honorable court, my lord, that my pending complaint was disposed. And in that order, in that reply order, again the respondent authority has upheld the earlier decision of the rejection of my technical bid. My lord. Basically, my lord, the facts of the case is like this, my lord, that petitioner, my lord, being eligible, is a registered Class 1A contractor, my lord, participated in the, my lord, NIT, which was floated on 14/3/2024. There are many packages were floated, many work, my lord. This case, you will.
My lord, before my friends, I mean, this package has been already re-tender, press tender as well, notice issued.
What is it, re-tendered?
Yes.
Now,
re-tender.
my lord, just today only, after filing this petition only, I have been informed, my lord, that now they are contemplating to initiate fresh tender process. My lord. Therefore, my lord, this matter may be posted for some other date, my lord. Time I will take the instruction, my lord, appropriate instruction, exactly whether we should proceed with the writ petition or whether we should challenge that cancellation of the earlier tender process. My lord. So this matter may kindly be then, especially, my lord, this submission may be recorded that particular for this package, the respondent authority has already initiated re-tender process. My lord.
Altogether 5 packages, they are, or 5 packages, including this present package.
The learned, I forgot your name.
G. Tarak.
Appearing for the respondents.
Respondent 1 to standing counsel RWD.
1 to 7, 1 to 6.
1 to
1 to
1 to 6.
1 to 6.
1 to
1 to 6 has submitted. that the package for which this writ petition has been filed, a fresh tendering process has been initiated by the government. Mr. Sonar, appearing for the petitioner, submits that he did not have the knowledge about the aforesaid fact. Therefore, Mr. Sonar prays for some time to take instructions.
My lord, this matter may be on 25th,
Again
25.
on 25.
My deeply.
In this case, I am informed that he is appear for all the respondent. My lord.
He will appearing for all the respondents.
All the respondents. Parame's petitioner.
My lord.
I'll be filing a wakalatama for respondent number 4, the legal heirs of respondent number 4. Is that already?
You file a reply.
Reply no.
You have no objection.
No, I have objection.
Then you file it in writing.
Okay.
Heard Mr. L. Parme appearing for the petitioner, review petition. Heard Mr.
DK Deori.
DK Deori appearing for the respondents.
All respondent.
All respondents.
No,
All
appearing for all the respondents. Fair. The respondents are directed to file a written objection if there be any. List after 4 weeks.
High level.
Maybe matter maybe for pass out for timing load.
No.
Nineteen also pass over for timing.
This IAS for what? Bail.
Yes, my lord. My lord, in this case, it's a very short matter, my lord. In this case, my lord, the accused was convicted under section 304 part 1 and sentenced to undergo for a period of 10 years by the session judge Pasigat. Now, thereafter, my lord, the appellant has filed an appeal before my lord. And along with the appeal, the appellant has filed an IA claiming the first time before my lord. Thereafter, my lord has passed an order directing the session judge to determine the age of the accused and submit a report, my lord. If I may take my lord to page number
in the IA,
my lord. There's an order, my lord. Order was passed on 12/12/2024, my lord. I'll read the relevant paragraph. Para 17, my lord, page number 8.
Yes.
Without expressing any opinion with regard to the documents so relied upon by the applicant appellant herein, in support of the date of birth of the convict Barkat Ali, it is hereby directed that the applicant appellant herein shall approach the learned session judge East Siang District, Pasigat, with an application along with the original copies of birth certificate of the convict Barkat Ali and a certified copy of this order. On receipt of such application, the learned session judge East Siang District, Pasigat, shall fix a date for proceeding in the matter, and on the said date as well as on the subsequent date so fixed by the learned session judge East Siang District, Pasigat, the jail authorities shall produce the convict Barkat Ali before the learned trial court. The learned session judge East Siang District, Pasigat, shall thereafter proceed to determine the age of the convict Barkat Ali by strictly following the procedures so mandated under the provision of subsection 2 of section 94 of the Juvenile Justice Act 2015 for the purpose of said determination and also for ascertaining the authenticity of the documents so produced in respect of the actual date of birth of the convict Barkat Ali. The learned session judge East Siang District, Pasigat, shall call for and scrutinize the original records. The said process of determination of age shall be so concluded in a manner
noted above within a period of 60 days from the date of receipt of the certified copy of this order, along with an application as directed to be submitted in the matter by the applicant herein, on the determination as required being made, the conclusion so reached shall be submitted by the learned session judge East Siang District Pasighat before the registrar of this court within 21st of February 2025. Accordingly, my lord, the appellant has filed an application before the learned session judge Pasighat for the determination of the age. And the report must have been, my lord, by now submitted and is in the record, my lord. I have gone through the records, my lord.
No, how much was the punishment?
Punishment was, my lord, culpable homicide not amounting to murder, 10 years with a fine of rupees 10,000, my lord. And as per the determination of age, my lord, he has been declared as 15 years, 11 months, 15 days, my lord. If my lord may kindly use the records, my lord. Records there. I have gone through in the morning.
The district judge's order.
Yes, my lord. The copy.
Where it is mentioned?
Has been. My lord allows me, I'll just place it.
So it.
This is the forwarding which has been received from the district and session judge Pasighat. And in the last page, my lord, observation has been given after determination of a convict, my lord.
29/07/2016 is the date of occurrence.
Yes, my lord. So my lord is aware of all these facts, but if my lord allows me to place a short authority as to.
That's not required. One is for bail.
Yes, my lord, for this, for suspension of sentence, and other is for.
One for suspension of sentence and one for bail.
One for suspension of sentence and one for one is main appeal, and one IA is for consideration of the application directing the learned district and session judge for determination of age. Altogether, two IAs, my lord. One is
age is already determined.
And he has been declared as 15 years, 11 months, 15 days, my lord. So in that case, my lord, in case my lord is not disposing of the main appeal, my lord, the bail may be considered at this stage. And
I'll consider a bail.
My lord.
Which one is for bail?
IA, my lord.
95.
Yes,
Mr. J. Seri, the learned counsel for the applicant. It is in IA 95. 95 AP 2024. Heard Mr. 2025. Heard Mr. J. Seri, AP for the applicant. Heard Mr. T. Ate, the learned judicial public prosecutor of State of Assam, State of Arunachal Pradesh, Para. This application has been filed under section 430 of the BNSS 2023, praying for suspension of sentence and for allowing the applicant to go on bail. Para. The applicant Mohammed Abdul Haq,
Barkat Ali, my lord.
huh?
Barkat Ali.
Muhammad Barkat Ali.
Barkat Ali.
Barkat Ali was convicted by the Court of Sessions at Pasighat in Sessions case number 13 of 2017. He was sentenced to undergo rigorous imprisonment of 10 years. During pendency of the appeal, he pleaded that he was a juvenile on the day of occurrence. This court in IA Criminal 103 AP 2024. 2024. Directed the learned session judge Pasighat to determine the age of the applicant.
On your date is your lordship on 12/2024.
Date of occurrence.
Date of order, your lordship.
This court by an order dated
12/12/24.
directed the session judge Pasighat to determine the age of the applicant. The learned session judge, after an inquiry, held that the applicant was 15 years, 11 months, and 15 days old on the day of occurrence. Para. I have considered the submissions made by the learned counsels on both sides. Under the given circumstances, it is hereby directed that the sentence imposed upon Muhammad Barkat Ali by the learned sessions judge Pasighat in sessions case number 13 of 2017 shall remain stayed till disposal of the connected appeal. Para. The applicant Muhammad Barkat Ali is allowed to go on bail of rupees 25,000 with a surety of like amount to the satisfaction of the learned sessions judge. With aforesaid direction, the ISN disposal.
Deeply obliged.
This IA, it can be disposed of. And then write in IA 103 of 2024. In view of the order passed today in IA Criminal 95 AP of 2024-25, the present IA stands disposed of accordingly.
Deeply obliged. Obliged.
Yeah, thank you.
Your lordship may pass order in the main petition, your lordship. Let the matter be listed after your lordship 2 weeks, your lordship.
Which one?
On main petition,
Oh, in the main appeal, in the main appeal, you write, list this appeal after 2 weeks for hearing.
yes, your lordship.
For this, which appeal? Item number? Non-appears for the list this matter after 3 weeks. Item number 25.
25, yes, your lordship. It's a criminal appeal, your lordship.
Criminal appeal.
Yes, yes. So we.
Who is for the appellant?
Appellant, your lordship, inform me that he is present today on. Your lordship may kindly pass over for the timing. I will inform him, your lordship. Because the senior counsel also.
Okay.
Lordship, and item number 15, Lordship, is criminal appeal. Last occasion, Lordship, the court has directed to amend the course title, wherein the victim name was, they have reflected victim name, so it is directed to withhold the victim's name. So as per the record, I have gone through, Lordship, it has changed, Lordship, they have amended, page, Lordship.
They have amended.
Yes, Lordship. So today, Lordship, notice may be issued on where the victim party, Lordship.
Who is for the petitioner?
Lordship.
F2, I will take it.
Lordship.
F2. Because the petitioner is absent.
Yes.
F2. Okay, F2.
Any day to your lordship's convenience.
Hard, Mr.
A. Sharma.
A. Sharma. APA for the appellant. Hard MS.
LHG.
H. Lakshmi or Lakshmi?
LHG.
LHG.
Yeah.
United Additional Public Prosecutor for the State of Assam.
State of.
The appeal is admitted for hearing. Issue notice. No formal notice is required to be sent to the respondent number 1 is because MS Hage has accepted notice. The appellant shall take steps for service of notice upon the respondent number 2. How you will send the notice?
Through the PP or we have the address otherwise.
Lordship, it will go through the registry to the PP office, Lordship.
Through the PP also.
Through the office of the public prosecutor, as well as by registered proprietary. Call for the LCR, list after 4 weeks. In the I, how much was the punishment?
10 years.
10
versus.
years.
Then you have to file an action also.
Lordship, that's why, Lordship, we want to, Lordship, LCR may become, Lordship. After, Lordship, actually here, Lordship, the punishment is 10 years and it's a POCSO matter. So, Lordship, it be better if it heard together.
But there are good grounds for moving this application for suspension of sentence.
All right, Hard Mr. A. Sharma appearing for the applicant. Hard MSL Hage United Additional Public Prosecutor for the State of Arunachal Pradesh. Issue notice. No formal notice is required to be sent to the respondent number 1, as because MS Hage has accepted notice. The applicant shall take steps for service of notice upon the respondent number 2 through the office of the public prosecutor as well as by registered prosecutor.
Any day to your lordship's convenience. That's the date should be there. Only prayer.
Third April.
3rd
April.
May.
April. Notice will come or not?
I think notice will not come back by that time, 3rd April. Let it be on the first week of May, lordship. I think by that notice will come and then the private respondent will also appear.
On 6th April, 6th May.
6th May. Yes,
on list this matter on 6th May.
Yes, your lordship.
Right.
Can it be on 7th?
Okay, 7th May.
7th May. Lordship. Item number 19. This is an application for restoration of a regular first appeal. For unfortunate reasons, this matter got dismissed for default, your lordship. Now the difficulty is the other side, the plaintiff, the sole respondent. We had served notice upon him. Okay.
Do you have objection?
Your Honor, my lord, today only I have filed my Baklatnama and I yet to receive the copy of.
The copy has already been served. That is how they are now appearing.
Next Monday.
Only the restoration if it is possible.
Yes, it is. It's a short matter.
Because what has happened is they are now proceeding in the execution matter on the other side. So if the matter can be restored, at least it can be heard on the next day.
My lord, since I have not received the copy, I cannot.
Then next Monday I will hear
Next
you.
month.
But no further adjournments will be given to you.
Yes.
Hard-
Observe that.
Petitioner, Hard Mr.
River, my lord. Rimo River.
Appearing for the sole respondent. The learned counsel for the respondent submits that he needs a copy of the application. The prayer of the learned counsel is allowed. Copy of the application shall be provided to him.
I'm serving him right now. Possible record, I'm serving him right now.
The copy of the application has been provided to the learned counsel by Mr. Sharma today. Release this matter next Monday.
20? 24. 20. Okay,
Yes.
sure.
25. How much was the punishment?
Lordship, the punishment is 9 years.
9 years.
Yes. Simply imprisonment for a period of 9 years. It's against the impugnment and judgment order 25 of 2019, Lordship. That is on. May, Lordship. From the paper book, Lordship, page 81. Is the
How many days he is in custody?
Lordship, if you count from the 2019, it would be 5 years, 10 months, like as of today, Lordship, from the day of his conviction. Okay, one set of that I don't have to see.
Okay, so what do you want to say?
Yes, my lord.
Respondent number 2.
Yes, one.
Three 304. Part
Lordship,
1.
the 304 has been altered to 3041, yes, Lordship.
302. 304 part 1.
Yes, Lordship. Read with.
Yes.
May I, Lordship? Lordship, here the district and session judge Teju has convicted the appellant only on the sole ground of 164 statement made before the SDO, that is Executive Magistrate Changlang, Lordship. Lordship, coming to the impugned judgment, Lordship, I'll just take it to the finding of Lordship, the session judge, it's in page 108, Lordship. I'll just be onto the point, Lordship. That is paragraph 41. Page 108, paragraph 41 also.
Yes.
This is paragraph 40, Lordship. And for the having carefully gone through the confession, that is paper exhibit 6 of the accused reproduced herein, I find the same well corroborating the prosecution case, and therefore this court, keeping the view that was cited law, has no reason to doubt voluntariness of the accused in making the confession. It is settled law that so and so the confession, if retracted at the time of examination of accused under section 313 CRP, can be relied upon if the same is found corroborating with other prosecutive evidence. And accordingly, I found the confession of the accused corroborating and relevant. 41 says, and therefore the established fact that the accused and the deceased were seen together in the night of 28 of 2012 in between 9:30 to 2 p.m. or 10 p.m. Availability of human blood in the house of the accused, recovery of dead body of deceased in the morning on 21 and from nearby place of the accused, recovery of weapon offense from the house of accused, post-mortem report showing cut injury in the dead, cause of death of deceased, followed by confession of the accused, not retracted till his examination under 313 CRP. Accordingly,
clearly form complete chain of circumstances, evidences to show the deceased who was seen with the accused in the night was killed by none other than the accused. Lordship, here there is no any eyewitness to the incident. The sole conviction is based on the 164 statement before the learned magistrate, Lordship. Lordship, my question before this honorable court is, Lordship, the 164 made before, and Lordship, before that, Lordship, the blood stain, the blood taken as a sample by investigation officer, they have not corroborated that the human blood or it's a human blood found on the offense of the weapon which they have alleged, and the blood stain found on the cloth had matched the blood of the deceased. There's nothing such, Lordship. That is the given in the FSL report also, Lordship, that
The weapon was also not sent to chemical examination.
was, but Lordship, they have not, it was sent, but they have not said that the blood found on that weapon matched the blood of the deceased.
There is no such report.
There is no such report, Lordship. It says, but there is no such report. So on the sole statement of 164, the largest, the learned session court has convicted the applicant, Lordship. Lordship, the 164 of the CRP says that the statement has to be taken by the judicial magistrate, not the executive magistrate. There is an settled law, Lordship. In regard to that, Lordship, I have a judgment. That is, Lordship, judgment 2017-5 GLT 144, Lordship. This is a division bench by our jail. This was division in here, the head note, Lordship. Evidence, confession statement, section 26, made in police custody in presence of magistrate. Query whether the expression magistrate appearing in section 26 of Evidence Act would mean the judicial magistrate or an executive. It was held, Lordship. Expression magistrate appearing in section 26 would mean only a judicial magistrate and not an executive magistrate. Division bench decision rendered in Anupam Das was affirmed, Lordship. In this case, Lordship. So, Lordship, the statement given before the executive magistrate, the 164, cannot be admitted as a piece of evidence because that ought to have been taken by the judicial magistrate, Lordship. In this judgment, Lordship, I'll not bother. It was discussed the state of Assam versus Anupam Das 2017 3 GLT, where the division bench said there is in Lordship says that the section 20 of Evidence Act would mean a judicial magistrate and not an executive magistrate. Lordship, in our case, it's a admitted fact that the 164 statement was taken by the SDO Changlang, who is an executive magistrate. That is not a dispute. So, Lordship, as part of this judgment, is that Lordship, the confession made before an executive magistrate as case should not be taken as an admitted as an evidence, piece of evidence on the basis of, Lordship, which this appeal is before this honorable court. So, Lordship, I will not bother the content of the case. It's Lordship, paragraph 32 to 33, Lordship. Paragraph 28, right from paragraph 28, it starts, Lordship. May I read, Lordship? No. Yes. Section 28, paragraph 20 says, Section 164 of Code of Criminal Procedure 1970 provide for recording of confession and statement by a metropolitan magistrate or a judicial magistrate as the case may be subject to compliance of condition mentioned therein. As per proviso to section 1 of section 134, no confession shall be recorded by a police officer or by any power of a magistrate has been conferred or any power of a magistrate has been conferred by any law for time being enforced. Before recording such confessional statement, judicial magistrate had to ensure that the person making such statement is completely free from police influence and there is no fear of such duress or coercion in the making of such confession. Moreover, as per section sub 3, if at any time before the confession is recorded, the person appearing before the magistrate stated that he is not willing to make confession, the magistrate shall not authorize the detention of such person in police custody. Therefore, if you look at the scheme of Code of Criminal Procedure 1973, it is evidence that it's only a confession or a statement is made by person before a judicial magistrate or a metropolitan magistrate, as the case may be. The same would have evidentiary value. It is in this context we have to examine whether expression magistrate appearing in section 6 of Evidence Act would mean a judicial magistrate or an executive magistrate. Paragraph 10. This issue was gone into a great detail by a division bench of court in Anupam Das. In Anupam Das, the division bench examined the definition of expression magistrate as appearing in section 3 subclause 32 of the General Clause 1987. The provision section 3, 6 and 21 of the Code of Criminal Procedure, as well as distinction between the confession under section 26 of Evidence Act visa under the 164 of the Code of Criminal Procedure. After detailed analysis, the division bench expressed the view is unequivocal term that it would be a strange logic if a state record by a judicial magistrate under 164 would be vacated for non-compliance of the condition mentioned therein, rendering its inadmissible evidence, but on the other hand, to hold the expression magistrate contemplated under section 26 of the evidence need to be not be a judicial magistrate and therefore under no obligation to comply with the requirement of 164, and yet such confession would be admissible in evidence. Thereafter, division held in the term expression magistrate occurring in subsection section 26 of evidence would only mean a judicial magistrate and not an executive magistrate. So Lordship, in our matter also, it's a fact that the 164 statement on the which the appellant was convicted was before an executive magistrate. Relevant portion of division in judgment in Anupam Das is extracted herein under. That is from 2021. I not need may I read lots about it. Okay. It's from paragraph 20, 21, 22, 23, 25, 27. Lordship, I'm coming to the last paragraph, which it says paragraph 30, Lordship, in this there. In the referral order, we find that the latter division bench observed that there appears to be some confusion in finding of previous division bench in paragraph 28, 29 of Anupam Das by pointing out that in paragraph 20, it was held that magistrate under section 26 need not be a judicial magistrate, but in paragraph 20, the magistrate under section 26 would only mean a judicial magistrate and not an executive magistrate. We are afraid we cannot accept such reasoning in the referral order. Paragraph 28 and 29 of Anupam Das have been extracted about. A plain and simple reading of paragraph 28 would go to show that previous division bench had observed that it would be a strange logic if a statement recorded by judicial magistrate under section 164 would not be admissible in evidence if the condition stipulated there had not complied with, whereas a statement made before an executive magistrate under section 26 of evidence where there is no procedural safeguard provided under section 164 of Code of Criminal Procedure would be admissible in evidence. Following such analysis, conclusion reaching in paragraph 29, the expression magistrate appearing in section 26 of evidence only means a judicial magistrate, but not an executive magistrate. There is no confusion here. The exposition of the legal position in Anupam Das is clear and unequivocal. Therefore, the observation made in the referral order that there appeared to be some confusion in paragraph 28 and 29 of Anupam Das perhaps was not justified. Refer to the Coroner Act 1870, where coroners appointed were deemed to be magistrate within this meaning of section 26 of evidence is misplaced for the same reason as alluded herein above, where the Coroner Act was enacted. There is no distinction between judicial magistrate and executive. Paragraph 32. The view taken in Anupam Das Supra was followed by another division bench in Ratan Singh vs. State of Assam 2012 5 GLT 796, wherein it was held that view of the provision prescribed by subsection of Code of Criminal, a reference to magistrate unless the context otherwise required, it is to be controlled as far as reference to a judicial magistrate. It was further held that making a confessional statement in presence of extra assistant can be treated as statement made in immediate presence of magistrate, while in a police custody it would hit by section 25 and section 26 of Evidence Act, and therefore and statement cannot be used as legal against the maker of this one. This is the view of Madras High Court in expression in several decisions in Palanis Sami Punjapayan versus State of Criminal Appeal. So and so, High Court held that evidence was enacted before the commencement of the Code of Criminal Procedure. In this view of Section 3, subclause 3 of the Code of Criminal Procedure, the term magistrate referred to subsection Section 26 of Evidence Act does not refer to an executive magistrate. Also, the expression magistrate as appearing in Section 26 of Act would only mean a judicial magistrate. Therefore, confession recorded or videographed by the police in presence of executive magistrate would hit by subsection Section 25 and 26 of Evidence Act. So, Lordship, in this matter, it was confirmed that the 164 statement recorded has to be before a judicial magistrate, not an executive magistrate. In this case, Lordship, our case, it was the 164 statement was taken before the SDO Changlang, Lordship. If you go to Lordship, even assuming for a moment, Lordship, if that statement was taken before a judicial magistrate, the judicial magistrate has not followed while taking a confession as under Section 164 subclause 4 of the CRP said that a retraction time also has to be given to the accused. Why he want to volunteer himself, giving the evidence against himself. Also, if we go to a record, it shows that the executive magistrate had failed to comply the provision as per the Section 164 subclause 4 of CRPC, Lordship. In paper book, Lordship, 8 to 11 is the confession statement. Here also, Lordship, no retraction time was given. When he was, it only says that he was sent from judicial custody on 14/9 of 2012 at 11 hours. At what time he had reached the magistrate before giving confession? At what time there was nothing recorded, Lordship. So, Lordship, this statement cannot be taken as a piece of evidence. Lordship, Section 26 of evidence also says if the confession is made, if the seized weapon has been found on the statement given by the alleged accused, then that can be corroborated, Lordship. Since, Lordship, here the alleged accused and the victim, that Lordship, what has from the statement of the PW from the prosecution witness also said that the Lordship, they was last seen together. But Lordship, the incident as alleged that the dead body was found from the quarter of the appellant 100 meters away. But only thing is that Lordship, in his room, the blood was found. There was a kukuri dao, and there was some blood stain and a cloth. And that, Lordship, that no blood stain, they have not matched with the victim, Lordship. So you cannot make out, Lordship, the conclusive proof that the blood found in the room of the alleged the appellant and the blood to be matched, Lordship. So there is nothing such like that, Lordship. Lordship, coming to coming to 164 statement also, Lordship, I would just like to take this 2024-6 GLT 579, Lordship. The same. In the same. Here also, Lordship, the chain of circumstances does it complete. The head note, Lordship, it says, your Lordship, it says, Lordship, section circumstances, evidences, victim hack with job posting that retraction at the stage of recording statement under section 131 CRPC, retraction confession statement held it admissible. Section 164 CRPC, omission to obtain signature of accused in consistent held fatal, not establishing that alleged weapon was used in assaulting disease, last seen theory not established, motive, absence of motive, motive, case resting on circumstances, evident factor, weight in favor of accused, additional missing link in chain of circumstances, appearance of accused in police station, though relevant under section 8, not as circumstances indicating guilt. Two views possible, view favoring the accused, adopted, chain of circumstances held not completed. Lordship, here also the appellant had killed her own mother and she had made a confession before the magistrate. Lordship, here in my case, it was also argued in this case that confessional statement must not followed as per the procedure is given in section 164 of CRPC. And there was no, just to coming to the operative portion, Lordship, it's a long judgment, but I'll just. This Lordship, page 775, that is paragraph 26.1, Lordship, the other. 26.2, Lordship, that is 28 and 20. I'll just go to the operative portion. I'll not burden you, Lordship. That is page 780, Lordship, paragraph 28, Lordship. Married, Lordship. Thus, it is well settled that in a case based on circumstances, evidences, each and every incrementing circumstances must be clearly established by reliable and credible evidence in the circumstances. So proof must be form a chain of events from which the only irresistible conclusion about the guilt of accused can be safely drawn, and other hypothesis is against the guilt is possible. It has been emphasized that time and again in the case, depending on circumstances, evidences, a possibility always loom in the conjecture and suspicious may take place of a legal proof. For the court has to exercise due care and caution to reach satisfaction that the various circumstances in the chain of event have been established convincingly, and such complete chain of should be such that it rule out a reasonable likelihood of innocence of the accused. When one or more important link in the chain of circumstances is or found missing and the chain resultantly get broken at place, then the other circumstances cannot establish the guilt of accused beyond all reasonable doubt. The eventuality of following suspicious to take the place at legal proof has to be avoided all stages. In the connection of this following observation made in case of Sujit Biswas versus State of Assam. It says, suspicious, however grave it may be, cannot place of proof. And there's a large difference between something that may be proved and something that will be proved. In a criminal trial, a suspicion no longer how strong cannot be permitted to take place of a proof. This is for the reason that the mental distance between may be and must be quite large, and a view vague conjecture for sure conclusion. In a criminal case, the court has to duty to ensure that the mere conjecture or suspicion do not take place of a legal proof. The larger distance between may be true and must be true must be covered by a way of clear causation and unimpeachable evidence produced by the prosecution before an accused is condemned as a convict. And the basic golden rule must be applied in such cases while keeping in mind the distance between may be true and must be true. The court must maintain the vital distance between mere conjectures and sure conclusion to arrive at one touchstone of dispassionate judicial scrutiny based upon a complete comprehensive appreciation of future of case as well as the quality and credibility of evidence brought on record. The court must ensure that miscarriage of justice is avoided, and if the fact and circumstance case is so demanded, benefit of doubt must be given to the accused, keeping in mind that the reasonable doubt is not an imaginary tribal merely probable doubt, but a fair doubt that based on reason and common. So, reverting back to fact in case, we find that retract confessional statement of accused is to be excluded out of consideration, and the same is inadmissible in law. The principle enshrined in section 27 of evidence as contained by the prosecution does not come in evidence, as the alleged disclosed statement of the discussed will not result in any discovery of fact regarding the alleged weapon and assault. That is the doubt. The prosecution did not establish the alleged weapon assault, that is the blood stain dog which was found beside the dead body of deceased was used in the assaulting the deceased. To establish the same, the proceeding was to have sent the blood sample, blood stain dog for serological examination, at least to find out as whether the blood group of the blood found in the said dog had matched with the blood group of the deceased as injured substance by disease, resulting in profuse bleeding. Lordship, here in our matter also, the blood sample was never sent. So in this matter, Lordship, here also, the convict was asserted by the High Court, Lordship. Lordship, just I'll go through the Lordship. Prosecution witness, they have given 12 prosecution witness. That is the PW1 is the wife, the PW2 who had shown, who saw the accused and the deceased as the last century, as the last. That is Lordship, and the entire prosecution witnesses that there was no any enmity between them. They were friends. They used to drink. They had drink together. So there was no any men's also. Lordship, on this part, whether I'll not burden Lordship, I'll just go to PW3 Lordship, who had seen them together. PW1 and PW3. And after that, I'll read. PW1 Lordship, page 35 of the of paper book, Lordship. Yeah, what says stated before the court, page 35. Yeah, Lordship.
PW1 is his wife.
His wife, Lordship. What on the day, Lordship, the wife was not present in the house. She had gone to her in-laws. So on the person staying out is my husband, so and so. In the year 2012, I was at Vijaynagar, Langham Saju. That is the disease is no more in this world. It took place on 28 August 2012. At that time, I was not present in our house, as I happened to be in the house of my mother at Bazar Line. I came back to our house on the morning on 21/8 of 2012. On the 28/8 of 2012 in the evening time, myself and my husband came from our house together, and I went to house of my mother, and there is Lordship, the alleged incident which took place 28. Myself and my husband came out from our house and went to house of my mother, and my husband was telling me that he will be in the house of Chingru Mamai, that is PW3. Next morning, next morning when I came back, I found my husband was still in the house of Chingru Mamai. At the time of my arrival, my husband was found sitting in the kitchen of Chingru Mamai house. After spending some time in the house of so-and-so, we went back to our house. When we came back to our quarter, which was allotted to my husband, we found that the door of our quarter is open, and from outside we have seen there was lots of blood inside the room of quarter. Therefore, without entering into the house, we went to police station and reported the matter to the police. This is Lordship. We have reported the matter verbally to the police officer. I don't remember the exact time, but it will be about 7 to 8 a.m. of the morning. Then police party came with us in our quarter. They entered the house to make inquiry about the same. Therefore, I went to house of Miss Ken. I have not entered into our house. Later, I learned that the dead body was recovered from nearby house. The dead body was of so-and-so, that is victim. Crossed by the defense lawyer. The accused husband and the deceased were good friends and they were having good relation. I never heard any quarrel or fighting between them. The deceased used to drink lots of liquor. He used to quarrel with other people also. It is true, deceased was residing at time in the quarter of Chingru Mamai. On 17/8/2012, Chingru Mamai came to our house and told us that the deceased has urine on his bed and made disorder the entire of the bed and cannot sleep in his room. Therefore, he went to sleep the night in our quarter. So here also on 17 also the deceased has went to sleep in their quarter, which we have allowed. On 19/8/2012, on the day time also the deceased came to our quarter with a chicken and request me to prepare the same, which I have prepared and have eaten the same. On the day I prepared meal for 3 persons, my accused husband, deceased, and Chingru Mamai. After having the meal, there was an argument between the deceased and Mamai about drinking habit of the deceased. Later on, I also came to know that on the night of 28/8/2012, deceased went to house of Juvenile, where he was offered a dinner by Miss Kane, but the deceased did not took the dinner. Rather, he poured water on the dinner plate. I was told by Miss Kane that deceased went to sleep the night in his quarter and was also saying that he went to see sleeping. He wanted to see sleep of Mr. So-and-so. It is true that I was told by my accused husband that on the evening of 28, that is date of incident, he will be sleeping in the house of Chingru Mamai. The character of my husband is good. He is not an aggressive person. I don't know blood which person I could belong to him. On 21/8/20, the behavior of my husband was normal. I don't think that my husband is a person who killed a deceased. If at all my husband committed the crime, there was a chances for running out of the area by my husband. I cannot say whether the incident took place at the time when my husband was sleeping in the house of Mamai. So, suggestion. And next, your lordship, to the page 38. This is the IO. The complainant, may I read on one word? I know a person standing on the deck. His name is so and so. He is a police personnel once posted at Vijay on 21/8/2012. That was the morning. I was in my house at Vijayanagar around 9:30 a.m. of the day. I started my journey from my office, which was about 1 kilometer from house. On the way to my house, I heard some noise from the people in the road. Before reaching our office at police colony, where the quarter of police were located, which will be at least 500 meters away from them, I met the staff of our office and also in the OC and other police personnel there. On my query, our staff colleagues told me that dead body of so and so is lying at the quarter of so and so, which is about 30-meter distance from. At the time of reaching in this spot, the dead body was already brought up from the deep gulch, which will be about 5 meters from the main. Was kept in the main. Dead body was taken nearby quarter of police, which was unused, and the dead body was kept near to one. I went to office and informed about the incident to then DC and ADC of Changlang through WT messages with a request for sending a chopper to brought back the dead body from Vijayanagar to Changlang. On 23/8 of the chopper came to Vijayanagar and taken to the Changlang. Till then, the dead body was guarded by our staff. After sending the WT message or DC, ADC, I came back to spot on day and visited the quarter of so-and-so along with the police. I have seen a black t-shirt belong to the deceased in the house of the accused. I have also seen kukri and torchlight and maybe also slipper in the house of the accused. All items were seized by the police. That is, lordship, that was seized was before the confession. I have also seen blood stain in the bedroom of the accused person. I have seen the collection of blood stain from the spot. Exhibit so-and-so are my signatures. Although I have seen the seizure of the mentioned by police from the PO, I don't remember the rest of items mentioned in the seizure list being seized by police. I have lost the FIR in the case of family member of deceased HR. Therefore, senior officer, I have lodged an FIR in the case exhibit. So is the FIR lodged by me in the case available in the case record of the courtroom. Original exhibit also is my signature. I don't remember whether I have given statement to police or not. At the same time of my arrival PO on the morning of our staff so-and-so or also present. Exhibit is the cookery shown to me before the court, which was seized from the house of accused on that day. Exhibit so-and-so, one pair is the chapel available for this person to which was seized by from the. That is cross on your lodge. I left my house on 9:30 to 10 on the morning and I reached the place where dead body was found. I don't remember the exact time, probably around 11 a.m. I have reached the office on the day. I don't remember the send WT message to this. I have taken at least 1.5 hours to drop and send. I don't remember the time I reached. I might have gone there around 12 on the noon. I might have lodged an FIR visiting a spot of second day, and this time about 1 p.m. I have seen the dead body of my own. It was already covered. I have seen the dead body uncovering with the help of police. The dead body wearing so and so. It is fact that in FIR I have not stated about the injury in of the dead body. The deceased was wearing a red color t-shirt and blue. I don't remember exactly where police says this one for the one piece or bought the piece of chappal level before this court. I cannot say whether the accused used the kukri or not in the case. The accused and the deceased used to roam together, but I had never heard of their quarrel or fighting. I have not heard any quarrel by the accused with any of the people. Whether he's a good loving person, used to come to village church and used to sing the religious song in the church. I don't know if the accused slept the night in the house of Chingro Mama. I don't know if there's any reason for killing this. I have not seen blood stain in between where the dead body was found in the house of accused. I cannot say whether the dead body was taken by deceased person. If suggestion was made, if the accused killed the deceased, he would have hide the material which was seized by the police from his house and is available before this. What do you say? Maybe, I cannot say the seizure of material from the house were done on the lead of accused or police by their own. I am not an eyewitness to the incident. As such, I have not seen the incident. It is true that deceased used to drink alcohol locally made. I cannot say whether the incident took place in the house of accused or not. It is true that there are more quarter in around a quarter of the accused person. Lordship, coming to the PW3, as part of the statement of PW1 and PW2, the deceased was supposed to stay all the night at his house. What statement he gives, Lordship? So long. This PW3, Lordship. I know the accused is standing on the dock. His name is so and so. Once he was at Vijaynagar at Constable APP. In the year 2012, I was at Vijaynagar. I'm working as LDC in the circle office of Vijaynagar. Late so and so was the driver of the CEO of Vijaynagar. Both used to reside together in my quarter. On 28 of 2000, at around 5 p.m. in the evening, I was coming back to my quarter. Late, the deceased and the accused were coming back from the market and was crossing my quarter. On my quarry, late so and so was telling me that they were going to police colony. In the evening, late so and so did not come back. Therefore, I went to sleep. Maybe around 8 p.m. Well, whole night it was raining at that night. In the middle of the night, so and so came to my house alone. When I opened the door on his knock, he came inside and asked him, "Where is so and so?" Accused replied me that he left so and so to the police Tana. Accused Tying left my home towards the market by saying that his family is in the house of in-laws, which is located in the market. After gap of 5 to 10 minutes, again accused came back to my quarter and slept with me for whole night. In the next morning, around 5 to 5:30 a.m., I woke up and went to the police colony in search of so and so. At that time, accused was already awakened from sleeping, but was still lying on the bed. At the time, nobody were woke up in the police colony and all are still sleeping. Therefore, I came back to my quarter. After coming back to my quarter, I started preparing my meal and I have to go to my office on time. When I came back to my quarter, accused so and so was still lying in the bed. However, when I started preparing my meal, accused wake up from the bed and went from my quarter, maybe gone towards the market. After a gap of 1.5 hours, accused came back to our quarter. This time he was accompanied by his constable friend. His name is called so and this time both them time and King was telling me that a person might have slept in the night and the quarter of accused time, but have left the quarter early in the morning. And there is a lot of blood stains spreading in the room of accused so and so. On the daytime, I request the staff of my office, including ALC, to charge the missing victim who used to drink. Therefore, I advise them to charge in the house where such drink used to sell. I personally also searched the deceased so and so, but could not find. Lastly, we came back to police college as there was a blood stain in the quarter of so and so. When we reached the house of Tang, police also came there. We seeing the blood stain spread in the quarter. Tang, we thought that if this is blood of human, the person will not, after losing such huge quantity of blood. According with the help of police team, we started searching nearby the jungle and hill as the police area located in the hilly and jungle area. After searching for some time, the dead body of so and so was from the deep gorges from the main. The dead body was not found very far from the house of accused, but I cannot say the exact distance. The dead body was picked up from gorges and kept near to the quarter of colony, which was unused and damaged. There we sent a WT message to DC Changlang with a request for providing chopper to evacuate the dead body of Changlang. I have given my test statement to the police and I have said everything for the police. Maybe on 23rd of August, helicopter came to Vijayanagar and the dead body was taken to district hospital now for postmortem. Before taking the Changlang by chopper, the dead body was got in the place. The accused time was also helping us in search of the deceased Sajung. I have personally seen the dead body from my house because I have lifted the dead body from the. I have noticed 2 injuries in the body of dead body. One of the forehead, which was not very large in size, seems to be caused due to striking. The second was in the front. This is which was very large, seemed to be sharp weapon. And the whole night was raining. The deceased was found in wedding. There's Nepali, the one torchlight and some cloth which was packed in gunny bag. I also seen the piece of slipper. I have also seen black t-shirt in the exorbitant, which was the deceased Sajung. I know the t-shirt we decided to. I have also seen the red color in the bucket of the rest is stated to be inside. I don't remember the P exhibit, the paper exhibit so and so or my signature in it. In cross-examine lordship, what he says that I cannot say the exact time so and so came to my house in the night as I didn't watch the time. At the time my mobile was switched off. I cannot say the exact time. Might have come around 10 to 10:30 at the time, but I am not sure. I cannot say exactly at the time. By searching missing so in early in the morning, I came back to probably it might have written by 5:45 or 6 a.m. It is not a fake. I was preparing for meal in quarter and coming back from search of missing Sajung on the calling time who was sleeping in a quarter had left my quarter with wife. He along with had left my quarter. I don't remember whether I have stated before the police that so and so left my house with wife in the morning. It is also true that I have given my statement for them. As it was already too long period, as such I don't remember whether I have given the statement before the magistrate or not. So as the accused was sleeping, suggestion was given as the accused was sleeping with you in quarter night. Therefore, the crime must have committed by someone else. What do you say? I don't know, sir. It is true on afternoon of 28 of I was coming back from house of Bosi, which is located in police. After playing card with them, that is, it was found I came to play card with them around 4:30 p.m. in my office. At the time of my reaching at quarter OC, 3 persons are already playing card. They were OC, Major, and King. I joined them. I left the place very quickly around 5 p.m. I have stated before police the same thing. I don't remember about the time. I don't remember if I have given my statement before the police that I went to quarter of OC at 1 p.m. on that day. I also don't remember if I have stated before police that want to be finished the playing card on it. I don't remember whether I stated before the magistrate on the day. I spent over 3 hours playing card in the house. I must not have told that time of my playing card either to magistrate or the police. At the time of playing card in the house of OC that the accused so and so was not present. My presence there was no counting of my presence there was no counting of money to find out who lost and who won. Now I remember it was Sunday, not the office day. After game is over, they were discussing to have drinks in the house of bosses. As I didn't drink, therefore I left the place. Was going for marketing for them. On the day to quarter, I met that is late, who was holding a chicken, who was crossing my house towards the police colony. I don't remember if I have stated before the magistrate. I was coming from the house of after playing card with the accused thing. I don't remember whether I have given a statement after we went to SIB came. I might have said so. I cannot say whether I have given a statement before the magistrate that I along with accused came to house of OC for it. On we made the deceased, so this is and who crossed us to report. It is too long to remember the same. It is
Okay.
so did
I have already gone through the evidence. This is not required. The day after tomorrow, I will hear them also.
Okay.
This is better day after tomorrow, as part.
Lordship, I'll just place one more judgment that maybe that is 2024 6 JLT 741. The same or not JLT, not the JLT, that same JLT.
Oh, the earlier JLT.
JLT, yes, Lordship.
Where is this one?
Page 741. And the SCC also, Lordship, that may be also There, Lordship, it's a long.
What it says regarding?
Lordship, here also the retraction.
No,
if not following the same.
That is not required.
My lord, on day after tomorrow, no issue, your lordship. But day after tomorrow, one more appeal matter where I have been endorsed in that case, your lordship. So because
Day after tomorrow.
yes, your lordship.
Then I will postpone that one. I will hear this one.
Okay, your lordship, then part.
That one I will give another day.
Yes, your lordship, that's fine. So that because I have to prepare with this case, otherwise again I have to prepare. Oblige, your lordship.
Deeply obliged.
30 and 31 to 31 also.
Your lordship may kindly take up item number 31. Issue in the both the matters are same, your lordship.
Who is
My-
for
My lord. My lord, by way of my lord, tender that your lordship will find at page 32, annexure 1.
Who is for Union of India?
Union of India, my lord, learned, in fact, it was informed that matter is going to be taken at 2. Name has also been shown, my lord.
He has to come.
My lord. But my lord, tomorrow, 11 o'clock, they are going to open financial bid. In that case, my lord, because no, my lord, your lordship will see page 32 first. Page 32, annexure 1.
What is this?
My lord, this is tender was floated for auction of coal mines for sale of coal at Namchik East Coal Block, my lord. As per my lord, tender condition that your lordship will see.
Where this place is?
My lord, it is in Chalang district, your lordship, in Arunachal Pradesh. Page 42, your lordship may kindly see page 42. Clause 3.3.
Yes.
Here, your lordship will see description of tender process. Pursuant to so and so, auction would be conducted through a 2-stage process comprising technical bid, in which bidders would be required to provide details regarding compliance with the eligibility condition. Second, financial bid comprising of initial offer, final offer. Initial offer is required to be submitted along with technical bid that we have done. It is hereby clarified that financial will comprise of 2 rounds. So, my lord, there are 2 stages. One is technical, another is, my lord, financial. In terms of these tender conditions, your lordship, we have submitted our tender that page 98 onwards, my lord. Everything has been submitted. In fact, bank guarantee over which 5 crore was also submitted. But all of a sudden, my lord, by impugned order, page 136, my lord, annexure 3. On 13 March, day before vacation, my lord. Page 136, my lord.
Auction of coal mine.
My lord. Say, my lord, so and so list of technically qualified bidders. So far as we are concerned in this matter, serial number 25 to 28, they were selected, my lord. They have been qualified without assigning any reason. What was the fault? What was the reason that we have not been selected? And your lordship, they have published this notice, and in the same day, 138, my lord, page 138, they notified that financial bid will be open on 18th March in respect of Namchik East at 11 a.m. tomorrow morning, my lord. And in respect of Namchik West, 11 a.m. day after tomorrow, my lord. My lord, we have been prejudiced, my lord. We don't know, my lord, without communicating anything, in utter violation of principle of natural justice, my lord.
Where is the other party?
Other party, my lord, they have chosen not to, my lord. In fact, my lord, when she is appearing, she informed 11:30 that matter is going to be taken at 2. Name has also been list, my lord.
And who is for the respondent number 2?
My lord, notice will go, my lord.
For 1 also notice will go.
My lord.
There is no other way.
My lord.
Third district.
A. Goyal, my lord.
A. Goyal appearing for the petitioner. Issue notice to the respondents. Petitioner shall take steps for service of notice upon the respondent by registered post with AD. When the notice will be served?
My lord, by registered posts. Because daily, my lord, I have to send.
4 weeks?
4 weeks. Till then, my lord, tomorrow financial bid is going to be open.
No stay.
Then, my lord, it will be infructuous, my lord. If your lordship will not, till then, my lord, otherwise, my lord, it will be infructuous, my lord. Because if they open financial bid, then what surviving my petition?
No other.
My lord, then in that case, my lord, there is no point of mentioning and moving, my lord.
It is your choice.
My lord, it is true, but my lord, kindly consider, my lord, I have given everything. I have given bank guarantee of 5 crore without giving me any reason why I have not been selected. My lord, it has been done. If my lord, my lord, till then, my lord, without leave of this, that much observation, my lord, no financial bid will be open without leave of this court, my lord. That much, my lord.
Nothing.
My lord, then, my lord, nothing, my lord, moving this petition, my lord, in the morning mentioning, my lord, and prima facie, my lord, there is no ground, no reason, nothing has been given, your lordship. In the impugned order, your lordship will see, only list has been given, no communication, nothing, my lord. My lord, all the persons are from outside, my lord, northeast, my lord. Only to favor them, my lord, without leave, my lord, that observation, if your lordship will not give, my lord, there is no point, my lord. Kindly, my lord, I am praying, your lordship.
No student.
My lord, your lordship may observe that without leave of this honorable court, it may not be.
What?
My lord, financial bid, your lordship. That much, my lord, I am humbly praying. Because otherwise, my lord, if they proceed, then it will be nothing infructuous, my lord.
No student.
I am not saying for stay, my lord. What I am praying for before your lordship,
No intent.
without leave of this honorable court, they should not finalize anything.
No intent.
Otherwise, my lord, your lordship kindly consider, if it is not, my lord, I am not pressing at all, my lord. I am happy with notice. But without this, my lord, nothing will survive in the petition, my lord, both the petition, my lord.
No intent.
My lord, what I am praying, my lord, let my lordship may kindly observe that without leave of this court, nothing will be finalized. That much, my lord, I am not for stay the entire proceeding. I am saying not.
Till returnable date? What?
My lord, this tender process shall not be finalized.
Concerned tender process shall not be finalized.
My lord.
Is it okay?
My lord.
Without the leave of the.
Without leave of this. In both the cases, my lord.
In both the cases, same order.
Same order. I bow down, my lord, deeply obliged.